So this is a little bit about Maternity Action, if you don't already know us. We well, I'll just let you read what that says there. It's all around, ending inequality and improving the health and well-being of pregnant women and their families. And we do a lot of work on pregnancy discrimination and employment law. Most of my colleagues are employment lawyers. So we offer several advice lines. So do have a look at our services. We have two particular services that target migrant women, and that is here's some hyperlinks to these: the Maternity Care Access Advice Service, which I'm part of that team, and that provides advice for women who have been charged for their NHS maternity care. And we provide legal advice and representation to those women. And I'm going to talk about the secondary healthcare charging regime in a bit. And also there's my service, which is a sort of capacity building and training service. So we provide free training to, health professionals, the voluntary sector, and various other groups. What's I going to say? Yeah, sorry. So there is links to these services throughout the slides. So I'm going to look at the whole system in the UK, both the asylum and the immigration system. So the UK has both an asylum system and an immigration system. It also has resettlement programs. Now, I'm sure some of these phrases will be familiar to people, and we'll go through them. So we look at asylum. This refers to the process of claiming asylum when someone comes into the UK, either at the port of entry, so you make yourself known to the immigration official, or in country at a designated place, a home office site. So people don't always claim asylum for various different reasons. They may have come through the UK, and we know a lot about small boats because it's a lot in the media about that. They may come on another type of visa and then claim asylum later. They may come on the back of a lorry. There's different ways in which people enter the UK, or they may just claim asylum at the port of entry as they arrive in the UK. It is difficult to claim asylum, as you've been increasingly hearing. There's plans afoot to change the whole system to make anyone who comes in an unregulated way not to consider their asylum claims at all. But that bill is still going through Parliament and still waiting to be concluded. So the ways in which people enter and remain in the UK. So as I said, people claim asylum on arrival, shortly afterwards, or when they have been in the country for some time. So I'm looking at asylum seekers. So whilst a person's claim for asylum is being considered by the Home Office, or if refused, most people have a right to appeal to the Immigration and Asylum Tribunal. They are known as asylum seekers. And that word, asylum seeker, means that they're in the asylum process, but also determines their right to support, what type of support they get and when they get it. And there's a hyperlink there to Right to Remain website, which is a brilliant website and is written in very much layperson's language. And if you want to know about the entire asylum and immigration system, their website is not to be missed. They have a lot of really brilliant information, and it's always been updated. And it is written, I think, in a simpler way than some of the stuff that we come across. And I think Right to Remain is written with the people who affects in mind. So it's a very, very useful toolkit and a source of information. So, as well as the asylum system, we have an immigration system, and they are all part of the Home Office, but there are different ways in which you enter the UK, or different ways in which your visa is processed on your asylum claim. So the immigration system, so as you probably are aware, people can apply for various visas to enter the UK from abroad. This includes students, workers, partners or spouses of those already here, and dependents of partners and spouses, and visitors. So visitors also come into the UK from various different countries. These people, these are time-limited visas, and they normally come with conditions attached. So this is the immigration system, and the biggest condition attached, which we're going to look at, is the no recourse to public funds condition, which I'm sure people will have heard that phrase over and over, because it is a very familiar phrase, but sometimes not understood what exactly it means. And we're going to spend a little bit of time looking at that. So people who are in the UK also, so you've got the immigration systems, so you're applying from abroad to enter the UK, as I said, in one of those routes, worker, student, partner, spouse, dependent, etc. There's also people who are in the UK and may have entered the UK in another type of visa, many years ago or more recently. And if they meet particular conditions under the immigration rules, they have a right to apply to regularize their status on something called family and private life grounds. And they have a right to make these applications because they meet the rules. Unfortunately, they're extremely expensive, and the fees are, shockingly high. And there is something called a fee waiver, which I'm not going to go into in this one, but I don't want to overload you information. But as I said, again, Right to Remain has some very useful explanations of what this is, how people who are already here and may have become undocumented, but meet the immigration rules and can apply to regularize their status here in the UK. So that's the immigration system. And a little bit more about the ways in which there's also something called resettlement programs, and I'm sure people are aware of these as well. So I've been working for quite many years now, since about 1999, in the asylum, working with refugees and asylum seekers. And I remember the costing program many years ago when I first started working. So there's been various schemes over the years, but some of them have ceased to exist, such as the Syrian program. I'm sure people will remember when lots of Syrians were forced to leave their homes and to come to the UK. And it was a really large Syrian program here, but that has since ceased. So the current programs and visa schemes, and you may have also heard of these. We've got one for Ukrainians, and that was a family and hosting scheme. And with these resettlement programs, what's different is that people come into the UK with leave in place. That means that they've either got like a vignette, they come in, they have a right to come in, and then they get their cards, that what we call a biometric residence permit when they're here, but they have leave in place. So it's like an agreed program in advance with the Home Office, and then people come in under these schemes. So the more recent ones have been Ukraine and Hong Kong. And what's different with these resettlement programs is they tend to have more rights than, say, people who apply for leave under family and private life grounds. Normally, people have a right to live and work and claim benefits. That's certainly the case for the Ukraine scheme, and we'll look at the Afghan one in a minute. And there was two schemes with Ukraine. There was a family scheme where you could join family members who are already here, and there was a hosting scheme, but the family scheme has abruptly ended. Again, the hosting scheme continues again. That link will take you to information about the rights of Ukrainians who are coming into the UK. And then we have the Hong Kong British Nationals Overseas Scheme. This group are given visas for either 30 months or 5 years and have a right to live and work in the UK. That group had a no recourse to public funds restriction applied to them. But we're going to look, they have a right to have that lifted off your leave. But as I said, in most cases, resettlement schemes, people tend to have more rights on a par with, say, like a British citizen. As I mentioned, there's after the Afghans, there's been two schemes. They haven't operated brilliantly. They came about when there was an evacuation, and there's two schemes. There's more information about that. This group have a right to live, work, and claim benefits in the UK. So either they're applying to come in and have leave, or they came under the evacuation program, were given leave. Unfortunately, many Afghans got stuck in hotels here, and some of them are still in hotels. Possibly because of the pace of the scheme being very quickly and stuff, but they haven't had an easy ride, and there is complications with the Afghan schemes in terms of it's slow to respond to the needs of these people who need to leave Afghanistan, either because of their association with British troops or being interpreters and all sorts of stuff. But there's more information in that link if you're particularly interested in the Afghan scheme. There's a generic resettlement scheme that's been operating for some years and is facilitated by UNHCR. So this is another resettlement scheme. Again, not great numbers of people come under this generic scheme, and they're identified usually in refugee camps in their neighbouring countries to where they are. And just want you to note that nationals from countries listed in these slides may be in the UK who come under the resettlement schemes on other types of visas, such as students, workers, or maybe in the asylum system. We know that a lot of those coming in small boats are from Afghanistan. So either they haven't been able to access the schemes and are still in need of protection, so are arriving on small boats or through other means and claiming asylum. So although these schemes are open, some nationals from these countries may be in the same with Syrians, and may be in the asylum system or have another type of visa here. So as I mentioned, normally, this is a very key document, and it's going to be phased out soon. It's like a credit card, and it tells you what type of residency or permit, she's short-term leave, not residency, yes, residency too, a person has or possesses. So anyone applying for leave in the UK for over 6 months will be issued with a biometric residence, a BRP, if their application is successful. Some will pick up their BRP shortly after entering the UK. So for those applying abroad, visas are applied for through their embassy or consulate. So you're a student or a worker and you want to come into the UK, and you have, there's rules and regulations around work visas and student visas and dependent visas of these. But normally you're applying from your country of origin through your nearest consulate or to where you're living, and you have leave in place when you enter the UK, but they will have conditions attached. These kind of what we call short-term leave, or limited leave, rather, is the term, limited leave to remain for a particular purpose. So those applying from the UK, within the UK, will be issued with BRPs from the Home Office. So if you remember, I spoke about people who have built up a family and private life, and they apply to the Home Office to regulise their status, and they will be issued, if they're successful, within the UK with their BRP. And as I said, and the reason I'm going into this detail here, which seems like a lot of detail, is because it connects directly with what type of support the person may or may not be entitled to. And we're also going to look at sort of safety net options for people who are not unable to access the benefit system. As I said, the Home Office has plans to phase out the BRPs and is moving to a digital status. I think it starts in December and it'll be likely afoot in early 2025. I don't know a massive amount about this, well, very little about this digital status and what that will look like. But it basically will be, the physical card will disappear. And I just wanted to give you some examples of what these look like. So I said the biometric residence permit looks something like this. And I just want to give you a few examples. Now, it's very hard to get images of biometric residence from the internet. So a lot of these are very dated. But you'll see the idea, I suppose the take home here is that it will show you the type of leave a person has, how long it's for, when it was issued, and they contain the biometrics as well in these cards, fingerprints and stuff. So yeah, but it's very hard to get these images, so they're all kind of out of date and look a bit odd. This person has a student visa, and you see that, leave to remain. And then the last one, this is someone who's claimed asylum. It's slightly different. So they have an application registration cards. So the type of visa a person possesses, and if they have a BRP, directly determines what kind of rights and entitlements they have here in the UK. I'm going to stop in a couple of slides so we can have some questions. So as I said, the rights and entitlements are directly related to the type of visa you have, or the type of leave you have, short-term leave, or whether you're in the asylum system and whether you're going through the asylum system. It also affects your rights to secondary healthcare, because some groups of overseas, what the NHS, and these regulations come from the Department of Health. That's the secondary healthcare regulations. And they have a different system for identifying someone's residencies. So certain categories of people who are overseas visitors will be charged for secondary healthcare, and we're going to look at that in a little bit. So there is also people in the UK who have no form of leave, either because their visa has run out or in the process of applying for leave to remain. And these are what we term as undocumented migrants. They may be here making an application, they may be poised to make an application, but again, we're going to look at their entitlements and what is available if this group are destitute. So as I said before, many of those who are granted visas, short-term visas, time-limited visas, will have a condition attached to them. And the most common one is the no recourse to public funds. This condition, the no recourse to public funds, will also be attached to people who apply here, who are in the UK and who apply here under the immigration rules. So, you know, people who are working here or students here will have other rights, like to work, sometimes short-term in terms of students, but most of these groups will have no recourse to public funds slapped onto their visas. And I think we may have, I'm just going to look, I'm going to go on for another couple of slides, and then I'm going to open it up for questions, either in the chat or if people want to speak. Okay, so what does this mean, the no recourse to public funds? It's not an immigration status, because over the years I've come across people saying, I'll say to them, because I give advice, second-tier advice, what's the person's immigration status? Because that's always the starting point. They will say, oh, they've no recourse to public funds. Now, that is not an immigration status in itself, because it applies to various different groups of migrants. So it's an exclusion or restricting affecting various groups of migrants, including those with leave and are perfectly lawfully here in the UK. So it's an exclusion that's placed on your visa or your limited leave to remain. And it applies to students, workers, partners, fiancés, visitors. Obviously, they normally come in for up to 6 months, and they have very few rights here in the UK because they're meant to be self-supporting. But other groups, also students, workers, partners, and we've got people, as you know, a lot of people have come under the care worker scheme, and that group, and that's increased substantially over the last year. That group do not have access to public funds either. It also affects those who, as I would say, make in-country applications. So they've been here, they've got a right to apply, and they apply under the immigration rules, and granted leave and family and private life grant also affects that group. Will have no recourse. That's been in place since 2012. We are going to look at, some people have a right to have it lifted off their leave in certain circumstances. So we're going to look at that in a minute. I was talking about asylum seekers earlier. It's not that they have no recourse to public funds, they do by default. But that group, since 2000, are supported by the Home Office under a parallel system of support. So they're excluded by benefit rules rather than Home Office rules. And I remember when that came into place in 2000, when they were removed from the mainstream benefit system, which they were entitled to get income support, job seekers allowance, and work and stuff, and then they were moved onto a parallel system of support that's been created. It was called NAS, and you might have come across that term, or Section 95 or Section 4. So you've got asylum seekers and refused asylum seekers, some limited number of refused asylum seekers in their own support system, a parallel system of support. And there's a link to our information sheets. And I'd also say Maternity Action's information sheets are very user-friendly and easy to read. So we're looking at the groups who have no recourse to public funds. So we've got the students, the workers, the visitors, the fiancés, dependents of these groups, those who apply while they're already here under the immigration rules. They're successful, they normally have it applied to them too. Asylum seekers are outside of the benefit system, and undocumented migrants, because they have no leave here, will be unable to access most forms of, well, all forms of benefits, the benefit system. And this will often be written on, if you want to know somebody's immigration status and whether there's any particular conditions attached, it'll be written on the back of the BRP. And it'll just have something like that, no public funds. And it might say something like work allowed in the case of students for a limited number of hours a week, workers, dependents as well, who have a right to work of various groups. So, and what are public funds? there's a whole list, and I've given you a link there to the Home Office that lists all the different public funds, well, all the funds that are classed as public funds, all the benefits that are classed as public funds. So you will see it includes things like child benefit. It also includes things like working tax credits, which a lot of families in the UK, in work benefits, which is what a lot of families in the UK will depend on to help, them meet the cost of the living needs. And we know that the cost of living crisis is going on, and there's been massive hikes in bills and food. So these groups of migrants that we're talking about if they're excluded from public funds, and they won't be able to get the in-work benefits that helps many families here in the UK. And as it says, there's a full list there. And before I stop, I'm going to look at what's not a public fund. So if you pay, so we come across this quite often on our advice line, contribution-based benefits, so based on your national insurance contributions. And because we've got a particular focus on women in this presentation, includes statutory maternity pay and maternity allowance. So somebody has come into the UK, maybe we're seeing it with care workers contacting us. They have paid enough national insurance contributions, so they'll either qualify for the statutory maternity pay, even though they've no recourse because it's not a public fund, from their employer, or if they haven't built up enough contributions or haven't worked long enough, they may be entitled to something called maternity allowance. And Maternity Action have loads of information sheets on our site about all of the different maternity payments and rules and regulations, and when you can take leave, and all the stuff to do with being in employment and becoming pregnant or a new mother, and advice for families. Education, that's secondary and primary education, is not a public fund. Neither is the NHS. And when we're talking about public funds, we mean the term used by the Home Office. But some groups of migrants may be chargeable for some forms of, for secondary healthcare, including maternity care. And we're going to look a little bit more in a minute at other types of support available. I also wanted to say, it's part of this series, my colleague will be giving an overview of NHS charging regulations. I will touch on it today for secondary healthcare, and with a focus on because of what we do on maternity care. And I'll stop there because I think I'm probably halfway through, and give you a chance to catch up. Would anyone like to ask a question? Or Brian?
Alexis, yeah. Hi, can you hear me okay?
Yeah.
Excellent. I just had a question about what's classed as secondary NHS care.
Yeah.
Particularly in regards to maternity.
Yeah.
So am I right in thinking that the actual delivery, in terms of labour, would that be classed as sort of the primary healthcare, but then anything after that would be classed as secondary?
No, it's all maternity care, most of it, unless provided by community midwives. Again, it's chargeable, the whole thing. So pre, post, and labour as well. The whole lot comes under secondary healthcare charging. And I'm going to look at that because all aspects of pre and post and delivery are chargeable as a package. And for maternity care, whilst we're on the subject, it's, the charging regulations in 2015 or 14 introduced a 150% tariff. So basically, you're charged for 50%, you're charged 50% more for the secondary healthcare you receive, basically. And in the case of maternity care, you'll charge 50% more. So the average is around £8,000 if you are a chargeable individual. So all of it is provided. I mean, some of it's provided by the doctor, but they normally refer then into the midwifery teams at hospitals, at trusts. Does that answer your question, Alex? I think so. Yep, my hand went up.
We've got another question, Gerry.
Yep.
I have an asylum-seeking lady who is 4 weeks pregnant after what appears to have been a date rape drug. What help can we access her to? Thank
If she's an asylum seeker and she has made a claim for asylum, which it sounds like she has, asylum seekers are not chargeable for their secondary health care. And I'm going to look at primary healthcare. Everyone's got a right, regardless of your immigration status, to access primary healthcare. So I'm going to look at what primary healthcare is as opposed to secondary. And for that woman, I mean, obviously, you know, anyone working in supporting victims of sexual violence of this kind, I would suggest you try and get her some counselling from one of those services. But in terms of her healthcare, it depends on what she wishes to do, but she'll have, if she's made a claim for asylum, she'll have access to secondary healthcare free of charge. Whether she wants to make a decision about keeping the baby, all of that, yeah, is free of charge to her.
Okay. Don't think we have any more questions.
Okay, let's plow on then. Hopefully, just to remind you, there's plenty of links in this presentation that you can look at, and I am aware it's a lot of information to take on. So this no request to public funds that causes lots and lots of stress for families who are subject to it, those with leave here in the UK who are excluded from, as I said, those kind of in-work benefits, as well as, you know, stuff people need access to in order to, you know, pay their bills, pay their rent, buy enough food for themselves and their children. It does cause a hell of a lot of stress on these families. And, you know, they're often assisted by charities to access like food parcels and stuff, even though they're lawfully here in the UK, they cannot access the extra help they need. There is a policy where you can have not a policy, rules where you can have, in certain circumstances, you can ask to have the no recourse to public funds restriction lifted from your leave. It's an application process made to the Home Office. It can take some time for it to be so somebody is awarded leave, and, you know, normally with those who apply on family and private life grounds are normally given batches of leave for 30 months at a time, and eventually they're on a route to settlement here in the UK. So they might, you know, have a series of applications they need to make, and to get to that time period where they can apply. And in the meantime, many of this group will be subject to the no recourse to public funds restriction. But the Home Office allows, so it's discretionary that they put it on somebody's leave. So if somebody's applying under family and private life grounds, and there's what that actually includes. See, as a partner or parent, that lists those who are applying on family and private and the categories that they fall into. So if someone is making this application, sometimes they will make an application at the same time not to have the no recourse to public funds put on their leave because they're unable to manage, or they, you know, for different reasons. People have young children. There might be a child that has special needs. There might be various that will restrict the family's ability to work. So they may apply up front, or they've been given the leave and then apply to have it lifted. So, and also, as I was saying, the Hong Kong British Overseas Nationals can also apply to have it lifted off their leave. Now, you don't need a lawyer to do it, but it's advisable to get help if you are assisting somebody or somebody wishes to have it lifted off their leave. The Unity Project has lots of really useful information on its website, including little videos showing what the application looks like, what kind of information you need to include. And this is a changing area of law. They've often, somebody like the Unity Project has done a lot of legal challenges to have this policy expanded to include as many people as possible who are affected by no recourse to public funds. So it's worth having a look at that thing, and it's just a little bit more about it. So those not normally eligible. So up until recently, because it is a discretion and the Home Office have discretion, it was only allowing families who were here on and had applied successfully on the family and private life grounds to have the restriction lifted. But there was a recent court decision where the person had not had leave, had leave as a student here, or she was actually a dependent of a student. And she challenged this decision, saying there's no reason why the Home Office cannot also consider other groups of migrants and ask and consider their applications, because they have particular circumstances, to have this lifted off their leave. Now, the case is complicated and it could have implications for somebody long-term leave going forward. So basically, the main thing I need to say here is that if somebody is to look at the information that is available from Unity Project, if somebody is looking to have the restriction lifted off their leave, because it can have implications for their long-term stay here in the UK. And I'm not a specialist in this area, but I would suggest that you look at their website, and they have updates on when they have won legal challenges and what that means and who it might apply to. We're also going to look at domestic abuse and a bit of domestic violence. So basically, there's more information about applications to live. So you have to have leave of some kind. Basically, if you're undocumented, you can't make an application to have it lifted because you do not have any leave. But as I said, it does apply to those given leave here in family and private life ground who are on a longer route to settlement here, and other groups now since that legal win, which was late last year. Again, there's a link there to the Home Office. There's also a link to YouTube videos about the application, what it looks like, and how you fill it in. And that's just a little bit more about having it and what you need to prove in order to have it off. So it's to have it lifted off. So usually, well, most cases, not usually, and it applies to people who are just finding it very, very difficult to manage without access to public funds. There's a risk of them becoming destitute. It's impacting on the welfare of their child, and they haven't got enough money, and they have a perfect right to be here in the UK, but they're struggling because they have no access to public funds. So this is another source of support for migrants who are victims of domestic abuse, obviously men and women, but in the majority of cases it will be women who are applying under these concessions. So it's recently changed. It was called up until recently the Destitute Domestic Violence Concession. So I just wanted to again, as making you aware of the different forms of support a woman could access if she is unable, doesn't have access to public funds. So those who enter on spouse, civil partner, unmarried, or same-sex partner visas, a particular type of visa, to join somebody here who's a British citizen or settled. So they're coming from overseas, they're coming to join a partner, husband, same-sex partner, and they're coming here into the UK. And after they've been here for 5 years, they have a right to apply for settlement in their own right. So settlement means like they're in line with, like a British citizen, they can apply for citizenship, but it's more or less entails very, very similar rights. So many, many years ago, Southall Black Sisters campaigned very vigorously on this issue, because what was happening was, in this case, was a lot of women who were not a lot of women who entering the UK on these visas were not able to access public funds and could work, but they were conditions where they live in the family home. They could work, but they had their family had to prove they were able to take care of them. If these women were subject to domestic violence, either from a family member or somebody in the husband, the wife, they were stuck in that situation and could not get out of it for 5 years. So they campaigned and had this concession, that if somebody was being subject to domestic violence, they could apply earlier it's for settlement in their own right outside of the family home. And to do that, they needed access to benefit for themselves and children they have, to get out of the situation, because they were locked into this cycle of violence and unable to leave because they had no way to support themselves if they were unable to work and stuff. So that's how it came about. It's recently, and it's a lot of work going on in this space for victims of domestic abuse. Many migrants are locked out of the system of protection. And so this has recently been, it's been extended to other groups, such as those who have domestic abuse who are on a work student or graduate visa. But unlike the group who come in as spousal partners or unmarried or same-sex partners, those particular visas, this other group, then the extended protection that doesn't mean they can apply for settlement after 3 months, unfortunately. It's just, it's been, I suppose, some concession to this group, but it doesn't have anywhere near the same rights and entitlement as those who come under the, I suppose, the traditional route of joining a partner here. Right to remain, there's a thing about the 3-month, the extension to this group. So have a look at that. I'm aware this is a lot of information. So I also wanted to talk about, if you are working with a woman who has no recourse to public funds, maybe doesn't have children, maybe does, but there is some refuge spaces, because often that is the first port of call, isn't it, for somebody who's fleeing domestic violence and needs to get out quickly. There is some refuge spaces, and there's some links there to organisations who may be able to tell you where you can get somebody out of a domestic violence situation and into safety. So they are those slides. Let me think. I think I might stop again just to give you a chance to ask a question.
We've got one question.
Yeah, great. So we have Hannah and we have Alex. Hannah, do you want to speak?
Hi, sorry, can you hear me?
I can, yeah.
Yeah, thank you so much. This is so helpful. This might be a little bit outside of the scope of what we're talking about, so no worries if it isn't possible to address this. But just while we're sort of on the topic of victims of domestic violence, I was just wondering if you sort of had a situation with a person who was seeking asylum and they were in Home Office accommodation and they were experiencing domestic violence. Do you know what the normal sort of procedure would be there in terms of, would they be able to use their Section 95 support to access a refuge, or do you think it would be more normal that they might just be moved to a different Home Office accommodation, like a different hotel, for example?
I'll answer a bit, and I think Brian, you can chip into this one too. That again, in this space, in asylum support, they campaigned quite for a long time to get the Home Office to have a policy in place for people in asylum support to be able to access alternative accommodation because they were at risk in their home. So there's a policy in place. Whether I should say with the Home Office, sometimes they're not always followed as well as they could be, some of the policies, but there is a particular, and I can send it in the slides, there is a particular policy for those experiencing domestic violence in their asylum support accommodation to be moved to alternative accommodation.
Okay.
And I can send that. Did you want to add anything, Brian?
Yeah, I think that's correct. I haven't kind of used the policy myself, but I think they can, there's an operational arrangement where the Home Office can pay for the refuge. And actually the Red Cross and Asylum Support Appeals Project is going to do a seminar on this on the 9th of April. So I'll put a link in the chat specifically on this policy. So do attend that if you're interested in this topic.
That's a good idea. Yeah.
I don't think they're going to record it though. So do attend on the 9th. That's my message.
Have a look. That's a good idea. So, Hannah, hopefully that answers your question. It is a policy.
Yeah, perfect. Thank you.
Yeah, and in that space again, I remember because I used to work with ASAP as well, the Asylum Support Appeals Project, just campaigning on, well, lobbying the Home Office to improve the system, because women were, or men, were, you know, in situations where it wasn't advisable for them to remain. Alexis, did you want to ask another question?
Can you hear me?
I can.
Fantastic, thank you. It was in reference to the last slide where you talked about the change in relation to what used to be the destitution domestic violence concession, where they would have access to public funds, but then could apply for leave to remain.
Settlement,
and that's now changed. So would they have to apply under another specific
No,
rule?
let me just go back to that slide. It's a good point. Yeah, I did whiz over that quite quickly. Yeah. Okay. So traditionally, it was called the Destitute Domestic Violence Concession, or the Destitute Domestic Violence. It was called the Destitute Domestic Violence Concession, and this, when somebody needed access to benefits in order for them to leave the home, in order for them to apply. So the group that traditionally, up until recently, was you could only ever apply for it if you were a spouse, a civil partner, an unmarried, and you came in on that type of visa to join somebody here who was settled or a British citizen. Yeah, so that still applies to that group. When someone comes under that route, they normally have no recourse to public funds for 5 years. They can work and stuff, but if they experience domestic violence due to that concession, they can apply for settlement earlier, and they can have access to benefits for 3 months, or it's extended and they need to put in an application for settlement. It's separate things. Gosh, what's my flash? Something's flashed on my screen. They need to apply for. Sorry, something's coming up on my screen. They need to apply within that 3 months for an application for settlement. Yeah, and there you need an immigration advisor to do that, and the application for benefits to tide you over. And if the application isn't sorted within that time and you've done within the 3 months, the benefits are often extended. So that still applies to the top group there. But it's recent, the concession has been extended, but not the bit about applying for leave to, in your own right for settlement. That is not available. What it extends is the right to benefits to get out of domestic violence or abuse that you may be experiencing.
Okay. Perfect.
Yeah.
Thank you.
It's a lot of information to take in, but the one down below, the right to remain, they outline what it is. So unfortunately, it didn't go as far as people wanted it to go, the lobbying. Yeah, so it's a good question. Thank you for that. It's helped hopefully clarify for other people as well. Okay, so I'm going to look at undocumented migrants, and particularly thinking here, so people who are undocumented at the moment, either because they are, and we've moved over to kind of safety net provision, really. So you're not entitled, if you have no leave, or you're in the form of applying, but you haven't had a result on that application, you have no documents, you're without any papers. So many of this group would be living on the margins of society and a serious risk of being exploited. We know that happens. So one safety net support, and I'm sure there's a lot of social workers or student social workers on here, is Section 17 support under the Children's Act. And the organisation that specialises in this area is Project 17. So I'd encourage you to have a look. I'm going to have a couple of slides on this, but they're the experts. There's a link to them. They give you information on the whole process of applying for Section 17 from the local authority under the Children's Act. What it means, what evidence you need, the type of questions you're going to be asked. It covers very, very comprehensive, it provides very comprehensive information on this. So this is right now. I meant to say earlier, I'm only covering England. I think I said on the slides, because there's different laws, similar provisions, but different laws affecting Northern Ireland, Wales, and Scotland, the other countries. Yeah. So my particular focus is on England because, because that is what we know the most about, given where we are based. But just to say that up front, that it's called something different in Scotland and possibly Wales as well. So what is Section 17 support? It's provided by local authorities. As I said, the duties will be similar in the different countries, but just called something different. Provided by local authorities as part of their duties under Section 17 of the Children's Act. Some families with no recourse to public funds may be entitled to Section 17 if they have children whose class is being in need, regardless of that child's immigration status. So it doesn't matter what the child's immigration status is. If their class is a child in need, the duty may arise. And there's a little quote. It should be the general duty of local authorities to safeguard and promote the welfare of children in the area who are in need. So a child in need, definition, if she or he cannot achieve or maintain a reasonable standard of health and development. And this group, if a child is homeless, living in suitable accommodation, family having difficulty feeding them, likely to be considered as a child in need. And local authorities should promote the upbringing of children in need by their families, which in most cases means supporting the parents along with the children. So you get this practice that we have no duty towards you, but we'll take the children. Absolutely wrong. Wrong in law. Children will only be removed from a family if that child is at risk from that family, and destitution can be overcome by providing them with support. So families are often scared out of approaching because they're told these things by social services, sometimes in gatekeeping, but it's wrong in law. If a child was to be removed, it needs to go through the court systems, you know, for an order for a child to be removed from the parent. So which families are likely to need it? It is safety net support for them and their children, those making applications for leave under the immigration rules, who are waiting on an answer, those who are preparing. So you really have to show you're poised to make one. So you have to have, when you approach the local authority under Section 17, they do a human rights assessment, and the social workers that are on here will know this. And that consists of is whether that person has any reason to be here in the UK. If they have nothing outstanding with the Home Office and they're not likely to be making anything with the Home Office, they don't fit into any of the immigration rules, they're likely to say, we'll support you to leave the UK. You and your children can get out of the destitution by returning to your country of origin. But if you have an application outstanding or you're poised to make one, then the situation, it's not reasonable to expect you to leave the UK. Also, families with leave who are unable to work, and these will be the families with no recourse to public funds. They would if they have children in need, they could apply to have the restriction lifted. That's one option. But if that's not possible, they, as a short-term thing, they may apply to under Section 17. Again, that family wouldn't be expected to leave the UK, but they have to show that there's a child in need. Refuse asylum seeking families with children born after a negative decision on an asylum claim. There's normally some groups of refuse asylum seekers are supported by the Home Office, depending if they can show there's a barrier to their return as well. So these are the groups who are likely to need it and who often do present to local authorities. So common problems accessing Section 17 supports. People experience gatekeeping, they experience long delays, experience hostility and suspicion, can be told children may be taken into care. Some social services may have immigration officials present. That used to be the case some years back, where they'd be sitting in on interviews. I remember I worked in Hackney, and that was happening across in interviews with. So that was causing, you know, a great deal of stress to families approaching who are often desperate, asking for extensive proof of destitution. Say they will do run bank checks, experience checks as well. So some useful guides from Project 17, as I said, and also the No Recourse to Public Funds Network is a great source of information on migrant rights and how, a bit like what I'm doing here, but in a lot more detail. And that's a very good source of, and that's aimed at social services and social workers. That's a very good source of support, because they're trying to promote best practice and an understanding of the law as it applies to social services, but they also cover other areas of support. Undocumented pregnant women. So it can be difficult to get support for this group because they're pregnant and don't have a child. That's really the take home here. Yeah, there's a pregnancy. So there's a couple of things I just wanted to note. So this affects women who are not refused asylum seekers. So if a woman's claimed asylum and has been fully refused, or the family's been fully refused, and they have no children, but they have children afterwards, or the woman is pregnant, you can apply for Section 4 support on the grounds of pregnancy, late stages of pregnancy, or a pregnancy that is complicated, because the reason you get it is you're able to undertake international travel. And have a look at our advice sheet on that as well. on Section 4. So I've come across women in the past who have never claimed asylum, who are here, who are undocumented, but are pregnant, either in the late stages of pregnancy, and one woman in particular had a particularly complicated pregnancy, so she could not, even if she wished to, fly because it was against recommendations of the doctor because she had serious complications. There is support under the Community Care Act for this group in limited circumstances, but you're going to need someone, a community care solicitor, because it's hard. Basically, what you're arguing is they can't be supported under the Children Act, they don't have a child, the Community Care Act, because they are unable to leave the UK because of the pregnancy, there's a barrier, and to not provide support would breach their human rights. That's basically the argument that is run. We've had a few successes over the years, but yeah, it can be very difficult for this group. But I just wanted to mention undocumented pregnant women, given what we do. And I'm a little bit, I don't specialise in this area, and it is going to change. Well, we'll see what happens in the next few months. National Referral Mechanism, which is for victims of trafficking, yeah? So basically, if you have to make yourself known to a first responder, if you're a historic victim of trafficking, a victim of trafficking, you can get a support system in place for this group under the UK's international obligations around the Trafficking Convention, and it's a framework for identifying potential victims of modern slavery and trafficking. And there's the Home Office guide to it is pretty comprehensive. If you have somebody who's a victim of trafficking, and they get into the support system in the National Referral Mechanism, but sometimes they're also making asylum claims. So I'm going to stop again, and then I'll go on to the last few slides, which is access to healthcare. So just to check, because we're nearly through, just to check whether there's any questions arising out of what I've just covered, which is Section 17, undocumented migrants, and a little bit on the National Referral Mechanism.
Yeah, we've got one question in the Q&A from Anne. In these circumstances, does social services not have a duty towards the unborn child?
Social services. Well, so you mean under Section 17? They were pushed back, basically. We have had cases, well, I have seen, I've known cases where someone is in late stages of pregnancy, depending on the social services. Sometimes I've been surprised. I've been called up by social services saying, looking for, sources of support for a woman they're providing who's pregnant. So it really depends. But the Children's Act doesn't talk about the unborn child, as far as I know. It talks about children. And so if that family could show there was a reason in late stages of pregnancy they could not leave the UK, and the Home Office or the social service were pushing back the Children's Act, it might be under the Community Care Act that you try. But you might persuade the home social services because the child's going to be here at some point soon. So yes, it really depends on the social services. It's not consistent, is what I'd say. You've Hannah again, I think.
Hi, yeah, sorry, it's me again.
That's okay.
I was just wondering, I feel like this gets to a really an issue that I've been trying to sort of get my head around in research recently, in terms of what support you could actually try and get for someone if they are undocumented and if they don't have children. And I was just wondering if you'd ever come across any cases where someone didn't have children, but they were able to get support through the Care Act. Because from what I can understand, the guidance seems a bit confusing, but it seems to be saying that their problems can't be a direct result of their destitution.
That's it.
So maybe it has to be some kind of health related issue.
Yes.
Which obviously seems like a completely redundant thing to say, because destitution causes so many problems. It's such a weird argument. But have you ever sort of had any cases where you've managed to get support for people through the Care Act?
Okay, because it rules out, like you say, if the destitution is mainly caused by, the need for care is mainly caused by destitution, it's in the rules very clearly states that isn't a reason to provide care. The only time we've seen care provided, as I said, those complicated pregnancies when somebody was undocumented, and if somebody has very serious, because it's a very high bar for under the Community Care Act to get, it applies to other individuals, not just undocumented or asylum seekers who have very high care needs. Because if you're in the asylum system, you have very high care needs, you should be additionally supported. The same with children who've got high care needs who are in the asylum system. But it is that definition of need of care and attention that is the one, and pregnancy does not bring that into scope unless there's a reason why that woman, the argument is she's unable to leave even if she wanted to because she can't undertake international travel. I haven't seen cases, I think it's very hard to get them to support if someone has a need over and above destitution.
Okay, perfect. Thank you so much.
That's okay. Very good questions, by the way. It's nice to get them. I'll press on in case I think the healthcare one might spark a few. So let me have a look. All right. Next to healthcare, we're going to just, last few slides, I'm just going to look at healthcare. And this is a real kind of, particularly secondary healthcare. My colleague, do look out for it. My colleague, I don't know when it is, it's in April sometimes, Brian. Do look out for my colleague's webinar, on charging for secondary healthcare. She's a great speaker, and she'll give a very good, I'm giving her a plug here, she'll give a very good seminar on this issue. So do look out for that. It's coming in April sometimes. Christine Benson is her name. So I'm going to look at access to healthcare, look at primary. So just to distinguish between what's primary healthcare, it includes GPs, community pharmacists, dentists, and opticians. That's it, basically. That is primary healthcare. Everyone in the UK, regardless of their immigration status, has a right to access primary healthcare. In the case of GPs, it's free, but as you know, we pay for dental, it's subsidised by an NHS, we pay for opticians unless you're on a benefit or you have what's called a HC2 certificate, which is available to people who it's not a public fund, so it's available to people who have who are on the low income or no income scheme, basically, and asylum seekers get HC2 certificates. So that's just a little bit aside there, but access to primary healthcare is available to all those here in England, regardless of their immigration status. To register with a GP, you normally need to live in their catchment area, and the GP is accepting new referrals. You cannot be refused for lack of ID. I know time and time again people say, well, they can't get past the reception staff. But I put that link there is to a very, very good NHS leaflet, and it may have even been updated. It was aimed at asylum seekers and refugees, but it applies to homeless people and other people who are undocumented as well. And it tells them you may want to print it out and give it to the person going to register with the doctor. If the doctor's open to new referrals and they're in that area, have been staying at least for the last couple of nights. And there is also Project London run by Doctors of the World as well, for people who are shut out or unable to get access to healthcare. They do have clinics. So is healthcare a public fund? Neither primary or secondary healthcare, and secondary healthcare is that delivered in hospitals or provided in the community by the hospitals, such as drug services, community midwifery. So secondary healthcare predominantly happens in the hospital. Neither of them, have I put our secondary healthcare, they're not classed as public funds. However, there's been charging in place for many, many years now, going back to, I think about 1997, very little charging went on. But since the 2015 regulations in England, there's been a lot more vigorous and a lot more people are being charged. And we deal with, huge numbers of women being charged for their maternity care who are classed as overseas visitors. And I'll look at that in a minute. So these are Department of Health regulations. So they're not a Home Office, although they cross over a little bit because of the immigration health surcharge. They can be charged for secondary healthcare, all forms of secondary healthcare, including maternity care, if they're not considered to be ordinarily resident or fall within one of the exempt groups. As I said, please do go on that course, because I'm not going to go into a massive amount of detail, because that is an hour and a half in itself, because the regulations are complicated. All maternity care is classed as being immediately necessary, which means it can never be withheld for want of payment. So it's unlawful to withhold anything classed as immediately necessary treatment for want of payment. Immediately necessary doesn't just cover, it covers all forms of maternity care, because maternity care is seen as essential for the well-being of the mother and the unborn child. it also covers, you know, very serious treatment that's needed immediately to prevent or to prevent a death or to stop something becoming worse. And it can never, those forms of treatment can never be held. It doesn't mean the person's not chargeable, just means that they can't withhold it, but will charge later. For more information on charging for NHS maternity care, please see that list there. And that's some very good information sheets, very easy to follow as well, hopefully. So the regulations are complex and poorly understood, which leaves migrants being wrongly charged. Which leaves, no, it should be the other way around. Sorry, it's badly worded. So we deal a lot with women who are wrongly charged for their NHS maternity care. Because they're poorly understood, most trusts in England have overseas visitors teams, and since charging became, it's now a legal duty for the Department of Health and Trust to identify who is chargeable and to charge those who are chargeable. So it's a legal duty. So since it's been put on that footing, and we've seen an explosion in charging for a secondary healthcare, and we particularly deal with maternity care. The regulation excludes exemptions from many groups of migrants, including refugees, asylum seekers, victims of trafficking, in the RM, unaccompanied children as a list of people in that group. And those who pay the immigration health surcharge as part of their immigration application are not chargeable for their care. So also what happened in 2015, you got in the immigration health surcharge was introduced. So if you're applying to come into the UK from abroad, you pay that immigration health surcharge. It's quite hefty now. It's over £1,000 per person, and it's usually for the length of your visa. And then if you're renewing it, you'll have to pay the same again. So have a look at what the immigration health charge is, and normally you pay it upfront. You also pay it if you're applying for leave in the UK under the Family and Private Life. It's part of the application. It means you've got access to all secondary healthcare except IVF treatment. There's also exemptions, and these are the more tricky areas, and we do a lot of work in this space for particular forms of treatment. So the person isn't exempt, but the services. So for infectious disease, you can see why that's there, or for treatment that has arisen from particular forms of violence. So treatment for torture survivors, we don't work in that space, but we do a lot of work around where the pregnancy may have arisen as a result of domestic abuse and violence or sexual exploitation. And what we're arguing there is the service that woman's receiving, including maternity care, is exempt because it arose from a particular form of violence. And last slide. So who's the main groups? And this is a very, very broad overview, okay? So these are likely to be charged. Undocumented migrants have a child here, no leave. They are one group that will be classed as an overseas visitor. A refused asylum seeker not on Home Office support. So anyone on Home Office support, either Section 95 or Section 4, is exempt by virtue of being on that support. Those in the UK on fiancés visas, not yet married, they're exempt. They're not exempt. Those waiting on a decision to regularize their status in the UK and currently have no leave, they have a child, say, chargeable. Those who had treatment when they had no leave. So you get historic NHS deaths that relate to when the person doesn't have it. Now, again, all of these have these caveats in them. And that's a more kind of complex side of the charging regulations, which we specialise in. So I don't want you to take that at total face value, but they're the groups that tend to be hit by charging. And then there's a little bit more about our services there. Okay, fine. I'm going to stop sharing. Is that all right, Brian?